Welcome, everybody. We are going to get started in just a minute here, but we're excited to have you. We're going to talk about the Supreme Court case relating to medication abortion today, specifically mifepristone. So welcome. We have a lot of folks at RSVP today, so I'm really excited as we let everybody in. And Amanda, I don't know if your children are around, but my toddler is just crying in the other room, which is always a fun thing to do for any sort of briefing or work event.
Yeah, it's 6 o'clock my time, so it's prime that
witching hour. Yeah, it's the witching hour. Yeah.
I don't have a kid, but it is that time where my dog Petunia like hovers around the kitchen like a shark and whines and expresses disbelief that we haven't fed her yet. And like threatens to call the ASPCA and claim we've never fed her. She doesn't know what food is,
It is remarkably similar for kids, Jess. I'll just say, at least for mine. Well, welcome everybody. I'm Erin Maye Quade. I use she, her pronouns. I am the Special Projects Advisor at Gender Justice, and I'm really excited to be joined with two of the most brilliant legal minds I've ever had the pleasure of experiencing, Amanda Allen and Jess Braverman. Amanda, introduce yourself briefly.
Thanks for that really incredible compliment, Erin. My name is Amanda Allen. I'm Deputy Executive Director for Legal Programs at the Lawyering Project. I use she, her pronouns, and while currently based in Baltimore, will always consider Minnesota my home.
Yes, and Jess, my longest esteemed colleague.
I'm Jess Braverman. I'm the Legal Director at Gender Justice. I'm the fake Minnesotan. Amanda was our co-counsel in our abortion lawsuit, and you always need the cred of like having the local counsel who's there. And so as the person from the Bronx, but I live in Minnesota now, I was the Minnesota local counsel, and Amanda, who like just shines through in every way as a Minnesotan, is like the East Coast elite. And so role reversal.
Role reversal, exactly.
Amanda, you're from Mound, right?
Monticello.
And we're going to talk today about the FDA versus Alliance for Hippocratic Medicine and the arguments that were happening today before the Supreme Court. And so I'm just going to give a 2 seconds on what the questions were before the court, and then we're going to kind of go through piece by piece how we got here, what the things are that are involved in this case, and what we think is coming next. So
we're also Amanda was in the courtroom, so we're gonna do a who wore it best black robe edition. So
and
stay tuned for that.
A lot of questions about being there. Jess and I both found out about a second before this started that Amanda was there. What time did you get in line, Amanda?
4:50 a.m.
Oh my goodness. And you were number
2 for the bar line.
Yeah. Wow. So you were in like the first row, second row.
Yep, second row. Great seat. It was worth the 4 a.m. alarm.
The questions abound, and I'm very much looking forward to hearing more about it. So the question before the Supreme Court today in this FDA versus Alliance for Hippocratic Medicine was whether the Alliance for Hippocratic Medicine has standing to challenge the FDA's 2016 and 2021 actions and how they changed mifepristone's approved conditions of use, and whether those actions were arbitrary and capricious, and whether the district court properly granted preliminary relief. But before we get into all that court stuff, let's just back up. Let's start with some facts about mifepristone and the FDA approval and changes over the years. So Amanda, tell us what mifepristone is.
Sure. So mifepristone is the first drug used in a 2-drug regimen for medication abortion. It works by blocking a hormone that's necessary to sustain a pregnancy, and it is followed by a dose of misoprostol, which is the second drug in the regimen. And it was originally approved by the FDA in 2000.
And talk about the safety or lack thereof, or how effective it is, just like what happens when you take mifepristone.
Right. So this is one of the safest drugs out there. It has been studied for decades now, and its safety record is pretty unimpeachable. It's safer than Tylenol. The FDA, when it was going through the process of approving the drug in the 90s, was looking at data from Europe and other countries outside of ours. in order to assess the drug's safety track record. And when the FDA approves a drug, it often isn't just the end of the story, approved, done. Studies and trials have taken place over the last nearly quarter century that have not only reaffirmed how safe this drug is, but have changed the best practices in terms of dosage and how to administer it and things like that. And those are all like very, very common things that happen in the practice of medicine. We saw it happen here with mifepristone.
And I think one of the things that Jess is just dying for me to say is, yes, mifepristone is safer than Tylenol. It's also safer than Viagra.
Yes, Erin's line in the Minnesota accent. Whenever I hear safer than Tylenol, I always think safer than Viagra.
Yes, it is. It's multitude safer than Viagra. Okay, so the FDA approves mifepristone in the year 2000. So at that time, what were the regulations? Like, how did you get mifepristone, or how did you dispense mifepristone? Like, what was the reality then?
So the FDA was under a lot of pressure to put a lot of strict requirements around the prescription of this drug. And so because of that, the FDA imposed something called a REMS on the prescription of the drug. REMS stands for risk. Oh boy.
Evaluation
and mitigation strategies. Yes, thanks, Jess. We just always talk about REMS this, REMS that. And a REMS is really normally used for a drug that has a likelihood of abuse, or has isn't as easy to use, isn't as safe and effective as a drug like mifepristone. But because of the intense political pressure the FDA was under at the time, they imposed this REMS program on mifepristone. And the REMS program has changed over the years, but to date, this drug is still under a REMS that basically dictates like the circumstances under which it can be prescribed, requires certain things for patients and providers to agree to, and things like that. But all along, a REMS was never appropriate for mifepristone, and especially now that we've seen how safe it is over the last, like I said, almost quarter century, it's even clearer that a REMS was never appropriate for the drug. But here we are.
So
yes, go ahead, Jess. Yeah.
Oh yeah. So for mifepristone, right? Like, we're going to talk about this lawsuit in a minute, but mifepristone is like singled out in this lawsuit as, claims that the FDA did something weird or wrong, or they rushed it through. Is any of that actually true in regards to mifepristone?
No, Jess. And no, I mean, this is a situation where the FDA looked at countless studies, trials, and like I said, looked to other countries to approve this drug. And nothing about the process was unusual. Nothing about the process was rushed. And in fact, what we ended up with in the process was an even stricter regulatory regime than was medically appropriate.
Yes, and that was certainly true. I think it was approved first in France in the late 80s, and it took all the way until the year 2000 to get it approved in the United States. And I think it's approved in over 100 countries. And the United States FDA approval is referred to as the global gold standard for pharmaceutical approvals and testing and trial and all of those things. Okay, so we know what mifepristone is. It is a medication, the first medication, and the two-step regimen for medication abortion. It is safer than over-the-counter Tylenol. It is safer than Viagra. It went through an extensive, longer than necessary probably, process to be approved by the FDA in the year 2000. It is the year 2024. Let's talk about what happened between the year 2000 and the year 2023 in terms of REMS, or regulations about how people dispensed and received mifepristone.
Yeah, so I want to parse out two different things. One is the drug's label, and the other is the drug's REMS. Because not every prescription drug in the United States has a REMS, right? We've discussed this, that it's something that the FDA imposes on a segment of approved drugs, but every prescription drug in our country that's FDA approved has a label. And so that's important because certain things are sort of at stake here and certain things aren't. The label for a drug is usually about the dosage, the administration, and those are things that that come from those rigorous studies and and all of the research that the FDA has put into approving the drug. But importantly, a label is not a law. So it's very common practice for doctors to prescribe off-label, and probably everyone listening to this right now has had a drug prescribed to them off-label. It's a very common practice. Drugs are approved for one purpose, and then somebody figures out like, hey.
And so sometimes it could even be like if there's a malpractice claim, what governs the standards of care might not even be what's on the label. Like off-label prescribing can be so common for a specific condition that the label, like, I think the reason we're raising this is because the other side is trying to make mifepristone seem like weird or experimental, or, if you don't use it in a certain way, but like off-label prescribing is super common. And in fact, it's physicians, it's doctors, it's medical professionals who decide how to prescribe. Like they're the ones who decide prescribing. The FDA just approves.
I'll give a really good example.
What? Yeah.
There is an SSRI. It's an antidepressant, anti-anxiety medication that the side effect when you take it at a low dose right away is drowsiness, but it's non-habit forming. And so there is an off-label prescription used for an antidepressant that's just a sleep aid because it makes people drowsy. That is an example of an off-label use.
Sounds like trazodone to me.
It is trazodone.
And the other example I was going to say is misoprostol is prescribed off use for inducing a miscarriage. Misoprostol was originally approved as an ulcer treatment. So this is like, there's nothing unusual about this. But that's the FDA's, the label that's accompanied mifepristone has changed over time. The REMS have also changed over time. And there's sort of a couple of key touch points throughout the history of mifepristone that I want to highlight. The first is the changes that were made in 2016. Because these are the ones that are really at issue in the lawsuit. In 2016, the FDA lifted some of the more burdensome requirements, including an in-person dispensation requirement. It also relaxed some of the rules around who could prescribe. And so if state law allowed it, the FDA said you don't have to be a licensed physician to prescribe it anymore. You can be a licensed clinician who is, practicing under their appropriate scope. And then in 2021, the FDA further made changes to the REMS, and that's when the FDA essentially lifted the ban on mailing mifepristone, which was a huge victory, because we know that in 2021 we were, COVID was raging and telehealth was, an incredibly important access point, not just for abortion care, but for all healthcare. And so that was based on not just, FDA just saying like, okay, this seems okay. But again, years of studies where clinical trials were taking place in the United States, showing that when patients received their medication abortion pills by mail, they had similar degrees of satisfaction. There were no health or safety risks. And so based on that research, the FDA said, we are going to officially allow mifepristone to be mailed. And then in 2023, the last big change was allowing mifepristone to be dispensed in retail pharmacies. So your CVS's, your Walgreens, that was not available until just last year. And so I point out those changes because what is at stake in this case is, do we time travel back to 2015, back to where we could not mail this drug, to where that was not available in retail pharmacies, to the old labels, the old forms, the old REMS that existed in 2015. So all of the FDA's actions from 2016 on are really what the Supreme Court is reviewing here.
It's 2024, right? It's 4 years after COVID started. We're all getting telehealth, right? Like we're all like, it's so common now. And of course the court is like, you have to take a horse and buggy to like yield like apothecary to get your medication. Like they're so behind the times that it's like, oh my God, telehealth. It's like, yes, there's telehealth for lots of stuff. Like when I had COVID, I couldn't breathe. I got a steroid over telehealth because it like I needed it. It was like a 2-minute appointment. You know, it's so common now. But this is the courts, right? Like they're willing to entertain like this kind of nonsense. Like they're just not like they probably don't even know what telehealth is. Like it would surprise me to learn that they're like aware of it.
I think one thing to just note about the anti-abortion movement's goal here, right? So recent data shows that from 2020 to now, the number of abortions in the United States, even with the number of abortion bans that have happened, are up. And more than 60% of those abortions are medication abortions. And part of the anti-abortion movement's work has been to carve out abortion care from the rest of mainstream healthcare, put it in special clinics with special doctors and special places with special rules. So they have
which can have special protesters.
These special protesters, you know, they target those clinics, they target those providers. You can't, and I'm quoting or kind of summarizing a really brilliant lawyer that I read recently. You can't target and protest someone's mailbox. You can't target and protest someone's telehealth appointment, right? And so it is to target the most common form of abortion that occurs in the United States in anti-abortion states and reproductive freedom states, and to continue to be able to target people who provide abortion care and people who access abortion care and the people who support them. And so like just to just really name what at the crux of this is that the anti-abortion movement knows that they cannot ban abortion fully while medication abortion exists and exists in this way, through the mail, via telehealth, and is allowed to happen safely and at home.
It's so much harder to stigmatize this care if it's happening in your home, right? If you have your telehealth appointment at home and then you get your pills 2 days later. And so I think you're exactly right, Erin, that the goal here was always to stigmatize, separate, treat differently, and medication abortion is a huge threat to that.
Yes. So let's actually talk about how the threat, you know, the anti-abortion movement and how they kind of formed around to create this thing to get this case to where it is. So let's talk about the Alliance for Hippocratic Medicine.
This case could be laughed out of a lot of courtrooms, but not in the courtroom that the Alliance for Hippocratic Medicine brought the case in. There's a lot of really wacky things that are important to know before we get to the SCOTUS oral argument. Because it helps make sense of some of the stuff that came up. So the Alliance for Hippocratic Medicine, what are they, Amanda, and their attorneys, Alliance Defending Freedom?
What aren't they really?
What
right?
aren't they? Yeah. Dentists who provide abortion.
It's a group of individual physicians, some retired, some not, and also anti-abortion medical associations, who banded together shortly after Dobbs to form this Alliance for Hippocratic Medicine, and very strategically filed this lawsuit in a federal district court in Texas, where they knew the case would land on Judge Kaczmarek's desk, and they would find no better.
A lot of his career as an anti-abortion activist.
Right, and so they knew that they would find no better ally in this cause, and so that was a very strategic decision on their part. Jess, you raised sort of who are they, and this came up a lot in the arguments today because in order to get through the federal courthouse doors, you have to have standing. Just basic concepts of standing means you have been directly injured by the action that you are challenging. In this instance, the action that's being challenged is FDA's approval and subsequent changes to mifepristone. And so how are they arguing that they have standing? None of them actually prescribe mifepristone. None of them actually provide abortion care. In fact, they all advocate in their professional lives against access to abortion care. And so the standing argument, and this was one of the, I think, biggest themes from the argument today, the standing argument rests on a series of hypotheticals wherein a patient who receives a medication abortion from a non-Alliance for Hippocratic Medicine affiliated doctor, then has a complication, goes to an emergency room, and then one of the Alliance doctors has to treat them, and by doing so, has to, you know, abandon or ignore the patients that they were already seeing, or provide a post-abortion care that violates their conscience, or any number of other things. But they could point to no fact in the record today that actually said one of these doctors has been harmed directly, has had to treat a patient in this exact scenario. And that's why I think Jess was saying earlier, you know, in normal times, in normal courts, like this would have never gotten past a motion to dismiss.
Yeah, even Amy Coney Barrett. So let's get to the oral argument today that Amanda was there for, and we're going to ask our ancillary questions after. But let's make sure like the substantive stuff. Oh,
yeah. Well, I was going to say, let's get to it. So basically, the Alliance for Hippocratic Medicine files this case in the Amarillo, Texas district, gets Judge Kaczmarek, who's openly anti-abortion. He writes this opinion basically like quoting like a blog post as if it's research, using really harmful terminology, none of which is medical, misquoting things, and essentially put an injunction against mifepristone in general. They went back to the year 2000 and tried to undo the approval of
he did a thing that's not even a thing. He's like, we're going to stay the FDA's year 2000 approval of mifeprex, you know, the generic name is mifepristone, which is like not a thing, but he did it. Yeah. Luckily that was like, at least that was undone, but yeah.
And then that went up to the Fifth Circuit on appeal, and the Fifth Circuit was like, well, we're not going to totally stay the approval. We'll just take it back to 2016. And so the Supreme Court was like, hold on, we're going to hear the case. Until that happens, none of this is in effect. And somebody asked in the chat.
Wait, can I say that's a super important point? So while we're talking right now, while we're waiting for a Supreme Court ruling, while all this is happening, mifepristone is just as available as it was like had this case never been filed. So until there's a ruling from the Supreme Court, nothing's going to change. The status quo is mifepristone is available as though this case weren't happening. So for folks who are curious what the status is now, that's what it is until we get a ruling from the Supreme Court.
Okay, so we get to today, and the Supreme Court has agreed to hear this case and answer the questions I mentioned at the top. Do the plaintiffs have standing? Do these doctors who might have to treat patients who took a medicine prescribed by a different doctor, though it's never happened in the 24 years that mifepristone has been approved, some future harm, do they have standing? That was one of the questions. So Amanda, let's talk about the arguments today. You're in the courtroom. What does it feel like? What is it like?
Well, it's only the second time I've observed arguments at the Supreme Court. The first time was to watch my colleague Stephanie Toti argue Whole Woman's Health 8 years ago. So, it's always very exciting to be in the room. And you know, it was also just everyone who argued did a fantastic job. It was, you know, just really, really good lawyering. I will say the thing that struck me overall was this repeated skepticism on the standing arguments. And that was across the ideological spectrum on the court. You had justices who leaned conservative, really, really hammering the attorney for the Alliance for Hippocratic Medicine on standing. You had the more liberal leaning justices. A lot of them just seemed unable to grapple with, like, how do we justify this case? And the Solicitor General, who is arguing for the FDA, really, I think, effectively made the case that if these guys come in on standing, then you're opening the floodgates to basically any interest group who says, I don't like this decision that was, you know, a federal agency made, and they don't have to prove that they were harmed by it. They don't have to prove they were injured by it. They don't have to prove it cost them anything. And so I think that to me, just based on my read of the room, that argument may end up winning the day again across the ideological spectrum on the court.
One of the most interesting moments for me is like courts are often really timid, really scared to get into like what is someone's religious beliefs, what's the scope of, they're allowed to, but they're very nervous about it. And the person to actually do that the most, I thought, was Amy Coney Barrett, who was like, okay, what are there, like, let's take let's get out of hypothetical land. Let's look at the declarations in this case. What are the physicians opposed to? And, the conclusion was that they were opposed to performing or completing an abortion where there's like a pregnancy that's consistent with a live birth, where the fetus is viable, or however you want to word that. So she was saying, if that's the scope of their objection, like, none of them have ever had to do that. And this was from Amy Coney Barrett, who was kind of pushing on this. I thought that was really interesting. Was that Amy Coney Barrett? I was listening. I couldn't see her, so
Yeah.
I recognized her voice. Okay.
Yep. That's right.
And so even she was like, but and I think the most
And Justice Gorsuch was very,
Oh, yeah.
very skeptical of the standing arguments, and sort of paired that skepticism with a comment about how, like, the standing is weak and the remedy is absurd. And so how do we sort of how do we balance those two out? And so you had Justice Gorsuch and Justice Jackson Brown kind of both making this argument of how do we justify, a handful of doctors who say they may have to do this one day speculatively, and then the remedy is nobody has access to mifepristone anymore. We're changing it for everyone, which is what the lower court did. It's not at stake anymore.
That was, I thought, like, Justice Jackson asked was like, she was on point, and like her two big lines that, like, she didn't talk the most by far. She was one of the quieter ones, but like her lines of questioning were the most on point. First, she was like, typically, if you have a religious objection, you seek an exemption, right? So like, let's say I am a doctor, I don't want to provide abortions, but a law requires me to, I seek an exemption, I get the exemption. They're like, because I have a religious exemption, no one can access mifepristone in the entire country. And that's kind of a bananas legal theory. And that was her first main point. And Gorsuch kind of took that questioning over, but it was annoying. Jackson was like asking really good questions, and Gorsuch is like, let me just interrupt.
Yeah.
You don't really know about like women's health issues. So it's just like, all right, Gorsuch.
The quote she said is, because they're saying, the doctors in the Alliance for Hippocratic Medicine, they're saying, because we object to having to be forced to participate in this procedure, abortion care, we're seeking an order preventing anyone from having access to these drugs at all. And she called it a mismatch. And I think that that's exactly right.
It was a diplomatic way of saying this is bananas. Like, it's a mismatch.
Yeah.
The second thing that I thought was so important was she was pointing out, like, okay, so the FDA takes scientific studies. They're looking through these scientific studies. They're scientific experts, medical experts. They're going through rigorous testing. What do you want a court to do with that? Like, are we pharmaceutical experts? Are we the ones who should be approving medication and second guessing their opinions? And I mean, I'm not someone who's like, let's just blindly trust anyone in a position of authority, but like, I'm not under the impression that I know more about like scientific studies, medication, and all these things than the people at the FDA. And I'm certainly not under the impression that the Supreme Court justices who are like learning about telehealth are more knowledgeable than the FDA. And Jackson, that's what Justice Jackson was saying. Like, why are you who are you saying should be the person to second guess? Like, not just say like the FDA didn't follow the law, but to say like, I disagree with how the FDA analyzed medical literature. And so I thought she brought two of the most important points, in my opinion.
Yeah, and that's the whole point of the FDA, right? Like, Congress has decided that the FDA has this expertise. They have processes in place to evaluate drug safety. And most importantly, perhaps, is that individual states aren't equipped to be their own mini Food and Drug Administrations. And this was a point that was brought up by a really great amicus brief written by a coalition of pro-reproductive freedom governors, including Governor Walz. And part of that brief was arguing, look, we defer to the FDA on these things. We don't have the resources or the expertise to know, like, okay, we're going to approve this. Like, that's not the role of states in our system of federalism. And I think that is like a really important point here. Like, we need the FDA we need to rely on the FDA, and we can't have a situation where every single decision the FDA makes, especially if it's on a hot button issue, gets second guessed by advocacy groups.
There was do we want to get to the wild card issue, the chilling part of the argument? Or do we want?
Yeah.
Okay.
So I want to eventually get to the things that were brought up that weren't related to the questions in this case, but are
like
far
EMTALA and
EMTALA.
But let's get to, so there were a couple of chilling moments in the oral argument that were about dun dun dun, the Comstock Act, where at one point Justice Thomas was like, you, Danco Drug Company, are going to be arrested and thrown in prison for mailing, like he was getting pretty close to saying that, like you're going to be arrested if you put abortion medication in the mail. So let's talk about what the Comstock law is.
Let's back up for non-lawyers, including myself. And this showed up, I remember when the Kaczmarek decision came out and Judge Kaczmarek referenced the Comstock Act. And that I feel like garnered a lot of headlines. People were very concerned. Amanda and or Jess, what is the Comstock Act?
Amanda, you get the pleasure and the honor.
Oh, excellent. The Comstock Act is a very, very old law that has been on the books for a long time. It's never been like repealed, but it's not been enforced for a very, very long time.
More than 100 years.
That's right. And it's based on sort of one guy's obsession, Comstock, as you might imagine, obsession with what his view of sort of moral purity was. And so the law says you can't, and among other things, put in the mail or use a private carrier to distribute medications used for abortions. And the list was very long. I think the list also includes, things that are of a lascivious nature or something like that. But the important thing to know is that many federal courts of appeals have essentially ruled like this thing is too old, it's not been enforced, and we're not going to let it spring back to life here. The OLC, which advises the federal government on various aspects of federal law, wrote a memo a couple of years ago saying just that, essentially, like this law is not meant to be enforced against telemedicine medication abortion, for example. And so you've got sort of a much more recent, like very, very powerful and weighty form of legal guidance. And then you've got this old law from, the 1800s that is just, in a different era all on its own. But Comstock continues to sort of haunt us, right? It comes up in all kinds of briefing. It came up in an amicus brief before the court, just on this case most recently, urging the court to essentially take up this issue. And so it's not, it's definitely, something that I think we were all listening for today, like, is Comstock going to come up? And come up it did. It came up a lot. Both Justice Alito and Justice Alito and Thomas, that's right, thank you, brought it up multiple times. One important thing to know is that they didn't have to do this. The two questions that Erin listed at the top are, do the plaintiffs have standing, and were the FDA's post-2016 actions lawful? Not did the FDA's approval of mifepristone conflict with the Comstock Act? No other questions. And when the Supreme Court is reviewing lower courts' decisions, they are not required to review things that are sort of not part of that lower court's reasoning and analysis. And nothing in the Fifth Circuit's decision, none of its reasoning, none of its rationale, none of its conclusion rested on Comstock. So the Supreme Court can absolutely just ignore this issue, right? It's not one of the questions that it agreed to take on. The Fifth Circuit's ruling didn't rest on it. And yet, we're all sort of waiting to hear, will it come up? And it did. And it came up, I think basically every chance that those two particular justices had. What were your reactions to it?
I mean, I will go to, again, the other brilliant legal mind in this, not mine, but I think the biggest thing that came up for
That's
me.
not true, Erin. That's
It
not
is,
true.
you're brilliant legal mind. I think what came up for me is the thing that I want people to know is that a lot of times we're looking at court cases that are going to change, I mean, and obviously rightfully so, that are going to change the landscape of abortion access that just happened in 2022. But the federal government and the executive branch, they enforce the laws. And so it wouldn't take a court to say, oh, Comstock applies here. Although I believe Judge Kazmarek was essentially saying that or raising the question, it would just take an executive branch to enforce Comstock and say that medication abortion is falls under Comstock and start enforcing it. And I do want to be really clear too that it's not just mailing it to patients, it would be mailing it to clinics, it would be mailing it to pharmacies, it would
Just
absolutely
passing it through the mail in any way by anyone.
Yep.
Correct.
But to be clear, we don't want folks leaving thinking like, oh, the Comstock Act abortion is illegal. Like, it's not being used in that way right now. We're not aware of anyone who's been prosecuted. And, as Amanda was saying, like, it likely wouldn't apply in a situation where the underlying thing being mailed is legal. Like, it's being legally mailed for a legally purpose. So Comstock is just being thrown out there as this, like, I thought Thomas and Alito were just trying to be like annoying and menacing. Like the specter of like, don't you care that you could get arrested? It just was really gratuitous. It was really unnecessary. And it's part of this overall strategy by anti-abortion people to kind of create chaos and sow fear so that people are too afraid to access abortion care. People are too afraid to provide it. Risk-averse lawyers who are advising big hospitals are like, oh, Comstock, don't do, it's meant to set off this kind of chaotic chain reaction, regardless of whether Comstock could be used to prosecute someone who mails mifepristone. So we're not aware of anyone who's been prosecuted for under the Comstock Act since 1873 for the mailing of mifepristone. So we don't want people to leave like terrified, but it is worth talking about, and it's something that they brought up for no reason.
And I think it's a good place to note like where they're trying to go, right? The lawyers for Alliance for Hippocratic Medicine said, we don't think that the court should empower the FDA to ignore federal law, with their assertion being that this federal law, which has been interpreted very, very narrowly, and is essentially, to my understanding, like not really something that's being enforced right now because it's so old and so broad. They're saying, no, it should absolutely be enforced. It should absolutely be this broad, and it should encompass medication abortion. And so it's important for people to know when the anti-abortion movement kind of raises up and unites around their next thing, it is contraception, it is bringing back the Comstock Act, it is no fault divorce, it is all of these things. It's saying that IUDs are abortion, it's going after emergency contraception. It's important when these moments happen, because having an attorney for Alliance for Hippocratic Medicine, which is part of the Alliance Defending Freedom, which undid Roe, like when they say that next thing, we should know that a large movement dedicated to saying this thing, that's probably one of the things they're going to be doing next. Just to be candid, I don't bring the mood down from this really exciting day. So Amanda, and I want to make sure we have time for questions as well, but I mean, so if people have questions, please make sure you put them in the Q&A. But you are in the room. Solicitor General Prologar is just one of the most incredible attorneys I've ever heard in my entire life. It's everything from the arguments to the diction, like so crisp, so prepared, not rushed, but speaks with confidence. What was that like in the courtroom, listening to the Solicitor General of the United States of America just be everything that I wish I could be?
I mean, I was in awe. I truly, it's hard to think of, something as compelling and smart and easy to follow. And yet she's just pulling, and all of them were really doing this, but just off the top of her head, cites to the record, it's all here. And I think she did a really good job of sort of responding to the questions and then making clear sort of like what's at stake. So she did a great job. She was like laughing and like hugging people beforehand. She seemed so calm. I know it was incredible. I truly, it really did feel like a gift to be able to be in that room today.
Yeah. And we were hearing, I mean, the oral arguments at the Supreme Court aren't video broadcast, but they're audio broadcast. It seemed like, and I'm just gonna give my opinion as someone who will never argue before the Supreme Court. It seemed like the justices who are looking for a way to ban abortion were kind of frustrated that this was the next opportunity they had. Like, it is not a well-crafted argument. It absolutely should have never made it to the Supreme Court. And it almost feels like they were like, really, you're gonna make us like not do what we want to do because your case is so bad. Did that come through in the courtroom?
It did a little bit. I got a little bit of a sense of like, can't you give us a little bit more? But the record is the record. And you know, again, this case should have never made it as far as it did for that exact reason. But I did definitely get that impression. And I like, you know, similarly got the impression that again, some of the more conservative justices are really skeptical on standing and really skeptical on remedy. And you know, that comes through with the way they ask their questions, their body language, their facial expressions, a lot of those things that really come through so much more when you're there in person.
Okay, what was some of the body, like, I have never seen them sit in a panel before. Like, what was their body language? What were their facial expressions? Any ones that stick out to you?
I'm not sure any stick out to me necessarily. But yeah, I don't think so.
Okay.
They were very, like, one thing about the court that's always just so striking is they're just so collegial. Like, even when they're like, they wanted, you know, they have their question and they didn't get to finish their question, but Chief Justice Roberts did a great job of sort of like, you know, making sure, like, did everyone get to ask a question? And it went over, right? That's the other thing, is that with a big argument like this, with 3 people arguing, it's supposed to be an hour. I think we were in there for an hour and 40 minutes. So you know, I thought he did a good job of like making sure everyone kind of got to ask the questions they wanted to ask. And yeah, it was just kind of amazing to be there.
So let's talk about what could happen. Oh, there was a question on Kavanaugh didn't ask any questions, did he?
He may have asked one of the Solicitor General toward the beginning, maybe
I was gonna
one
ask,
other.
was he like asleep? Like what was happening there?
He was alert as far as I could tell.
Okay.
But maybe just not particularly engaged. I'm not super familiar with his questioning style. Of course, Justice Thomas was like first question out of the gate. And I think did that for all 3. And yeah, it was, but yeah, not too much from Justice Kavanaugh, some from Justice Sotomayor, not a ton. I think those were probably the 2 quieter, of the justices.
And so do we want to talk about what your predictions are? I mean, let's be really honest. When we listened to the oral arguments for the Dobbs case, when we convened afterwards, I mean, before we were like doing a live debrief, we were like, they're going to overturn Roe v. Wade. Before the arguments, I was like, they're going to find a weird way to overturn Roe v. Wade without doing it. And afterwards, I was like, they're going to do it. And I wish we would have been more forthright about that, even though we were pretty public about it as a movement. But this is, I think, our opportunity to say what we really think will happen if lawyers are allowed to do that kind of guessing.
We're allowed.
We're
Yes.
allowed. Yeah, we're definitely, would love to hear all of your perspectives after listening to it. My take going into the argument was, I think that the FDA, I think the federal government is going to win this one. And that was based just on, you know, the just very basic legal issues that I think this case suffers from. So I was cautiously optimistic going in, but I'm a lot more optimistic now because of the kinds of questions, the kinds of scrutiny that I think the very basic, like, you cannot get past, you know, do not pass go, do not collect $200 if you don't have standing. And I think the questions that were asked again by judges across the bench on standing were pretty telling. And so that, to me, I think, and that's it, you know, if they don't have standing, there's no case.
Jess?
I was a little concerned. I didn't think they would be quite so opposed to standing in this case because they've granted standing to religious plaintiffs who are like, one day I may make a wedding website, and that wedding website will have like, they've given hypothetical standing to select people before. And so I was a little worried they do that here. I was really relieved that they were so opposed to it here. I just don't see it. Like, they're not going to have Connie Barrett. I mean, she was pretty like, I don't know what you're doing here. Like, without her, I just I don't know. So I'm feeling pretty good about that. My concern though is like the nonsense science. Like, there's such a push right now in courts all around the country to push nonsense science. We see it in gender affirming care cases too, where it's like, here's 1,000 really good studies, really solid studies showing this medication is safe and effective. And then here's one study about anonymous bloggers on the internet who are like, my kid is trans and I hate it. And like, that's a study. And courts are like, yeah, like, I need to take that seriously. And so like, that worries me because like Alito was clearly like, oh my God, everyone who takes mifepristone drops dead. Like, every single one, like, he was there. Thomas, I don't think, cares what the facts are. He just wants to ban it. I was a little concerned that there wasn't more of an uproar of like, you're bringing a case to nationally end like this medication, saying the FDA didn't do its job, and you don't have a single study that actually effectively disputes anything the FDA is saying. Like, that's like frivolous, right? Like, that's
And
sanctionable.
some of the studies that the district court relied on have been
Right,
retracted by the journals that originally published them because
right.
they were not up to standards.
I think for me, what you kind of both are talking about is this incredulity that it got this far, that they're in front of the Supreme Court, and that the justices didn't have this, like, how are we here? What is happening?
Yes.
Type
Like,
of attitude. That to me is almost more concerning because it tells me that they agree with the end goal of Alliance for Hippocratic Medicine. They just don't like that it was so blatant.
well,
And
it's
that,
also the shift of the wind, like the shift of like, it's, it'll be great when the like Supreme Court says no to this, and it's like, this shouldn't even be in front of them. Like, this shouldn't even be a thing. Like, what is it, the Overton window? Like, every
yes.
expectations have just shifted to the point where we're like, take whatever scraps we can get. Like, this is outrageous. Like, it is outrageous, and we allow it in this like age of disinformation and anti-science, and like, like, this should not be happening.
And I think that's the part that I want, that like, obviously I don't think that the Alliance for Hippocratic Medicine is going to have any wins here, but I think what's going to end up happening is that right before, the summer before a big election, the headlines are going to say Supreme Court doesn't limit access to medication abortion, and everyone's like, oh my gosh, yes, they are moderate, like they returned it to the
Right.
state, that's fine. But there's going to be a roadmap throughout the opinions on how to bring back the Comstock Act, how to actually bring the case, just like there was, I believe, in Whole Woman's Health, was the roadmap to get us to Dobbs, right? There in that dissent, there was that roadmap. And so I think I want us to not see a win in this case as like a win. It's really just, it was a ham-handed first attempt to get the goal that they're going for. And it was really embarrassing that this case got as far as it did. And it was also really concerning that that actually wasn't the tone and tenor of this debate, that they were treating it as serious as if it was. And I think there was a question earlier about, and there's one now about, is it true that Alliance for Hippocratic Medicine was incorporated in the region of Texas where this specific judge, Judge Kaczmarek, is the only federal judge? And yes, that is true. August of 2022, which was just a short skip and a hop after the overturning of Roe v. Wade. And relating that back to this new policy by the Judicial Conference to kind of prevent this issue of judge shopping. And what this policy said is that lawsuits that seek to have an injunction against a nationwide law has to be kind of assigned randomly. But that policy isn't a law. And do you want to talk about kind of what the impact or outcome of this judge shopping, much like happened in this case, what that policy could do?
It's basically like everyone's running to Amarillo, Texas, which is apparently the most populous and litigious of the of the like places in the United States. But they're doing it because they know that they will be assigned Judge Kaczmarek, who will be very sympathetic to certain plaintiffs. And so the Judicial Conference created a new policy that's, it requires random judicial assignments in cases with implications beyond like plaintiff defendant, you know, when there's implications kind of beyond just the people in the case. As Gorsuch, I thought was really like, he was like, in the entire time, who did he refer to? Like Roosevelt? He's like, in the entire time that FDR was president, there were no like nationwide injunctions. And now I have like 1,000 of them coming from one judge in Amarillo, Texas. And so the judicial system, the judicial conference realizes that this is kind of creating, like, people just aren't trusting the courts, and the courts don't work if people don't trust. Like I've said this before, they're like Tinkerbell. Like if you don't believe in them, they lose their power. Like what can they do if you ignore them, you know? And so they realize people aren't like believing in them, so they're like, we want everyone to clap, and so we're going to make it so that there's random assignments now. You can't just like file everything in Amarillo, Texas and be guaranteed to get a specific judge who will issue a nationwide injunction. Amanda, do you have any additional or other information about that?
No, I was just going to sort of say the same thing about Justice Gorsuch and his concern over the amount of, this extraordinary form of relief, right? Which is like a nationwide injunction. And I think the policy really does try to address that, because it's, again, not about like every single, federal case filed, but it's about if you are seeking this drastic of a remedy, you can't sort of pick and choose who you get to show up in front of.
And I think that's right. But I was listening to a really great law professor talk about how this policy isn't going to have an effect right away, but that it's kind of setting the tone for what people should be doing, and that judicial districts will maybe start doing this on their own, or judges that are in like they're the solo judge in that district will start doing this, so that the people who don't are the outliers. They're the standouts, and then it could possibly be addressed more formally.
I just don't think this judge cares that he's an outlier in the standout.
No. And the fact that he was confirmed to a federal district court is alarming. I mean, it is the stuff that he wrote before being confirmed as a judge, and the stuff he participated in is pretty egregious, and it's why they do the judge shopping. It's very clear where he stands on things. The next question we have is, this has international implications regarding reproductive rights. How do you foresee the decision affecting the United States being a leader in women's reproductive rights and women's rights for at least half a century? Good question.
That's really hard. Last summer I visited a friend in Colombia, and like they just legalized, they had a great outcome on abortion there. And it's like at the same time that we're rolling back abortion rights. I think it's really hard. I'm not really in a position to speak to like how the international community looks to the US. My assumption is there's like a delay, like as we're rolling back, like the countries that have just started to move forward, we might see a backslide there in the coming years. Like you see like Trump, like people being elected around the country, around the world. I don't know for sure. I don't know how much countries care what the US is doing. I imagine some do. I imagine even if they don't want to care, like, some might. I do think this could have implications. The thing that's important to keep in mind, though, is like the Alliance Defending Freedom, the attorneys for the Alliance for Hippocratic Medicine, they operate all around the world. Like they're trying to ban abortion, they're trying to ban LGBT rights all around the world. And so in the US, they know, for example, that they can't advocate for like the death penalty for gay people, right? Like that's not politically viable, but they do it in other countries.
Right.
And so they're the same organization that is working in other countries. So if they're having success here, I don't see why they wouldn't elsewhere. But beyond that, I can't really speak to I don't think I have enough information to know like the full scope of the international implications in terms of like how people look to us and what that'll do. I mean, some countries may be like, the US is going off the rails and we don't want to be like them. I imagine like that's happening somewhere too. So
Amanda?
Yeah, I mean, I think we lost a lot of credibility, what little credibility we still had as maybe a human rights leader when Roe was overturned. I think folks in other countries probably would look to that first over this, because this is a kind of technical case. But I do think also, because Erin, I think you were saying earlier, like the FDA's process in approving drugs is the global gold standard. And if courts in the US can kind of make an end run around that, then I think that weakens that that credibility as well. But truthfully, I think I think our sort of stature internationally has been pretty low for a while now.
Yeah, I mean, I think it's greatly diminished, and I think one thing we know is that the state of reproductive rights and freedom in a country, or lack thereof, is a good marker on where you are in the spectrum of democracy to fascism. And so I think it is a marker to the global community of where we are on a way to authoritarianism, fascism, and that other I mean, it is not lost on me that the same summer that the US rolled back reproductive rights, Mexico expanded it, Colombia expanded it. Recently, we had Ireland expand it. It's not lost on me that as other countries work their way to better, more inclusive, more representative democracies, America works our way backwards. And this is just indicative of that. It is not like a random thing that's happening contextless from everything else. It is part of that movement of, white Christian authoritarianism and white Christian fascism in the United States, and it's evidence of its success. And so that's what I think it is. I don't think it's, I just think it's telling people where we are. And there tends to be global movements, right? We see the rise in this type of movements around the world. We're not alone, but we do have currently unique abilities to combat it. The question is whether we are able to. There was a different question. When do you think the decision will be made?
End of June.
Yeah, end of June. Yeah, that's usually right around the anniversary of Roe, which will also give it a lovely, 2 years after undoing Roe, Supreme Court doesn't limit access to abortion. They are very excited to have these headlines. They, I believe that they're very, especially Roberts, and probably Coney Barrett and Kavanaugh, who care a lot about being seen as like independent jurists and like, calling balls and strikes and the legitimacy of the court, even though they've contributed much to its not. So that's probably when it'll happen. There's a question. I don't know if I could speak to any of this, and if neither of you can, that's fine. There was a question about the movement towards natural law and away from constitutional law. Amanda, do you have thoughts on that?
I do not.
I know it's like I don't know. I know it's like a Federalist Society thing. It has to do with like morals, like morality. But I don't feel comfortable speaking on natural law movement because I just don't know enough about it. I will say, like, I've done some looking into like jurisprudent, like court decisions on like morality, like legislating morality, because if you do LGBTQ rights, like there's all of these rulings that are about like, this is just, I don't know if this is in the Constitution. I don't know, like we have this law because everyone agrees that homosexuality is wrong. Like there's rulings like that throughout, and I think that might be movement to God's. Okay, so the person in the chat is describing it as movement to God's law as it interpreted by lawyers and judges. I know that there are folks here in Minnesota who advocate for this, including I know like Eric Cardall, who tried to intervene in the abortion case. He had a book about this exact thing. I think Michelle McDonald, who often runs for judge, believes in I think she has said, and correct me if I'm wrong, I think she has said something to the effect of like that the Bible, like you can kind of disregard the Constitution for the Bible, or like the Bible is just as important in interpreting the law as a constitution. There's a lot of kind of there are people who feel that way. I think it might be part of the Christian nationalism movement. Like it's the lawyer part of the Christian nationalism movement.
Yeah, and I think, as a person of faith, I'm Lutheran, but I always have to say I'm ELCA Lutheran, because there's like a bunch of different kinds of Lutherans. And so I think one of the most concerning parts is that this like movement for people to interpret laws and rights and abilities in our country through this lens of, God. Who's God? Which Bible? There's like a bajillion different Bibles and the books were written by a bajillion different people and added a bajillion different times. And so I think, it is this like effort. It is an effort to move us to a place that I think we would only joke about being or have written like dystopian novels about. And I think that the hard part about having conversations about this Christian nationalist movement is that it sounds like a conspiracy theory, except they're doing it all in public. And they say all the things in public. They write websites and books and make podcasts about, I mean, they say it in public, but it starts with fringe characters. And by the time it works its way into the mainstream conversation, it's been kind of like softened and dialed down so that it sounds something like natural law and not like white male heteronormative patriarchy control over every single person's life. Like, let's actually return it. When they said all men are created equal, they meant white men who are landowners, and like that's what we mean too. And so that's what it is. Just it's happening right in front of our eyes, but it's not the work that most people do every day. And so it pops up when there's a big decision or a big thing, and then goes away. I mean, the Alabama decision was rife with this, right? The
That's
IVF.
exactly what I was
It
thinking.
was like a sermon.
Yes, it was.
I went back to make sure I was not like defaming Michelle McDonald, and I was not. So what she said was she held a Bible aloft over her head and said, "It is impossible to rightly govern the world without God in the Bible," which is something she said in a speech about running for the Minnesota Supreme Court. Then when people were like, "Wait, what?" she said, "Oh, I'm surprised people took that literally."
Oh,
I don't know how else you take that, but she does run frequently. She's currently like disbarred, I think, but like when she is barred, she runs. So like, and people vote for her. She gets like, no one knows who she is. No one researches judges, or people do research, but a lot of people don't research judges before they vote. They see like, oh, a woman's running and they vote for her. Like this needs to stop. She got like 40% last time. And I think it's because people didn't know who she was. Yeah, we got to be a little careful.
I think that it's important to know that the movement to institute Christian nationalism is alive, well, and succeeding in the United States of America. And without a lot of work to peel back the layers, expose what's going on so that regular people understand what's happening, and shore up our constitutional protections and our secular democracy, we will be living in a time that is not something that that most people wouldn't enjoy, even Christians. I think it's a whole pyramid scheme that no one's going to thrive under. Well, Jess and Amanda, I think you should be the two to end this. So I'll go to you, Jess, first, and then we'll let our guest end. Any final comments before we wrap up?
Gosh, I don't even know. Like, I'm just bummed that it's like like what we've been talking about, that it's going to be considered this like good thing that they don't rule in favor of Alliance for Hippocratic Medicine, when really what they should be doing is slapping like sanctions on their lawyers. We're just shifting the window so much in terms of like, the election denial lawsuits, the gender affirming care bans, the abortion bans. It's the abortion, with abortion and gender affirming care in particular, it's like you have to look at who's bringing the claims, right? It's lawmakers who are antagonistic, who have animus towards LGBT people, who are opposed to gay marriage, who are opposed to trans rights, who are opposed to anti-discrimination law, claiming that they're passing a law to protect the very people that they're constantly attacking. It's disingenuous. But they do it over and over again, and the Overton window shifts, and we're all just like, oh, well, the court, it's not so bad. Like the court didn't rule in their favor, and it's like the court should be disbarring them. Like, this is nuts. This is bananas. So those are my closing thoughts. Yeah. Amanda will have like much more intelligent.
We'll see about that. Remember, I'm the one who's been up since 4 a.m. Yeah, I mean, I think the one thing I would love for people to go home with is there's a lot at stake in this case, for sure. But if the worst outcome here is not that this medication is banned nationwide, it's not that it's going to be completely pulled from the shelves, it's that, we're going to have to figure out how to live with, we're going to have to figure out how to time travel to 2015 and live with the old rules and regulations that, that existed then. But I always just want to caution people not to sort of like, okay, a bad decision equals like medication abortion ban everywhere, no matter what. And so I think it's really important to just remember that even a loss in this case does not take Miffy off the shelves.
Yeah, we try really hard when we send out information not to overplay the like abortion's going to be banned because of this lawsuit. We try to kind of be as accurate as we can, and Amanda's absolutely right. You can still like misoprostol is still legal, and you can provide an abortion with like it's we want people won't get the healthcare they need if they think it's not legal, and we don't want people to think that their healthcare that they need is illegal. So
I'll just say that the roadmap to overturning Roe v. Wade was starting to be written. I mean, it's been written over decades, but shows up in the Supreme Court decisions that we quote unquote won in 2016 and 2021. And so, is that right? 2016 for sure. It's too late for me now. And so that's what I expect this case to be a quote unquote win, and that nothing changes. But the roadmap to completely upending access to abortion care again is mapped out either in a dissent or in footnotes or in, random questions that I'm asking. And that's what we should all think of this case as. It's the beginning of the roadmap for the next piece that the anti-abortion movement has been working towards for a very long time. So we thank you so much for being with us. We will continue to keep you updated on things that happen at the Supreme Court, things that happen in the courts. I will always bring you the best legal minds and never do the legal analysis myself. Thank you so much for joining us this evening, and we will see you all very soon. Thank you.
Thank you for having me, Gender Justice.
Thanks for having.
thanks for coming, Amanda.
Thanks for coming, Amanda. You're always welcome.
Yeah, always.